Hi, my name is Corey Biazzo, and I'm a practicing American civil litigation attorney, and you are watching Executive Coup. In today's episode, we're going to briefly discuss the United States Court of International Trade's complex May 28, 2025 opinion that judicially renders President Trump's unilateral Liberation Day tariffs and fentanyl tariffs as legally null and void because they exceed the President's emergency tariff implementation authorities delegated by Congress to the President by statute through 50 United States Code, Chapter 35, titled the International Emergency Economic Powers Act of 1977, which we're going to refer to as the IEEPA. Thus, this situation appears to constitute the Trump administration once again violating the constitutional separation of powers and attempting to illegally usurp Congress's Article 1 authorities. However, we're also going to discuss the May 29, 2025 order from the U.S. Court of Appeals for the Federal Circuit, which followed the Trump administration's appeal of the ruling from the U.S. Court of International Trade on May 28, 2025. The May 29, 2025 appellate order puts a temporary hold on the May 28, 2025 order while the appellate court conducts a review of the substance of the case. The order also orders briefing in the legal issues from the parties to be reviewed by the appellate court in reaching its final decision on the merits. In regards to the May 28, 2025 order from the U.S. Court of International Trade that is temporarily delayed while under appellate review, the three-judge panel of the U.S. Court of International Trade began its 58-page opinion by referencing Article 1, Section 8, Clauses 1 and 3 of the U.S. Constitution by stating, quote, "The Constitution assigns Congress the exclusive power to quote, lay and collect taxes, duties, imposts, and excises, and to, quote, regulate commerce with foreign nations. The question in the two cases before the court is whether the International Emergency Economic Powers Act of 1977 delegates these powers to the President in the form of authority to impose unlimited tariffs on goods from nearly every country in the world. The court does not read IEEPA to confer such unbounded authority and sets aside the challenged tariffs imposed thereunder." In citing the U.S. Supreme Court, the U.S. Court of International Trade panel went on, quote, while Congress may not transfer to another branch powers which are strictly and exclusively legislative, Congress may confer substantial discretion to implement and enforce the laws. Thus, courts have consistently upheld statutory delegations as long as Congress lays down by legislative act an intelligible principle to which the person or body authorized to exercise that authority is directed to conform. The panel explained how the disputed statute came about. Congress has responded to the growing complexity of global economic relations by delegating trade authority to the President. These delegations have included clear limitations that retain legislative power over the imposition of duties and over foreign commerce. The panel goes on to specific delegations of authority from Congress to the President in the statute. The panel further discussed several executive orders issued by President Trump that attempt to trigger emergency economic powers that the President is delegated through the statute. Then the court discusses the stated intended invocation of the executive orders being to cut down on fentanyl trafficking from places such as China, Mexico, and Canada, and then the fluctuations in raising and lowering tariffs in retaliation to the change of tariff rates on the United States in response to President Trump's initial tariffs and the use of tariffs on countries outside of those targeted by the President's orders. The panel went on, quoting James Madison in Federalist No. 48, quote, "Underlying the issues in this case is the notion that, quote, the powers properly belonging to one of the departments ought not be directly and completely administered by either one of the other departments. Because of the Constitution's express allocation of the tariff power to Congress, see U.S. Constitution Article 1, Section 8, Clause 1, we do not read IEEPA to delegate an unbounded tariff authority to the President. We instead read IEEPA's provisions to impose meaningful limits on any such authority it confers. The statute, at the very least, does not authorize the President to impose unbounded tariffs. The worldwide and retaliatory tariffs lack any identifiable limits and thus fall outside of the scope of 50 United States Code, Section 1702. The panel went on to discuss how an unlimited delegation of tariff authority would be unconstitutional. The panel said that 50 United States Code 1701 does not authorize the trafficking tariffs because they did not satisfy the conditions that Congress imposed in 50 United States Code Section 1701. 50 United States Code 1701 subsection 8 states any authority granted to the President by Section 1702 of this title may be exercised to deal with any unusual and extraordinary threat which has its source in whole or substantial part outside of the United States to the national security, foreign policy, or economy of the United States. If the President declares a national emergency with respect to such threat, 50 United States Code 1701 subsection B states in part, any exercise of such authorities to deal with any new threat shall be based on a new declaration of national emergency, which must be with respect to such threat. The panel concluded its order by stating, quote, the court holds for the foregoing reasons that IEEPA does not authorize any of the worldwide retaliatory or trafficking tariff orders. The worldwide and retaliatory tariff orders exceed any authority granted to the President by IEEPA to regulate importation by means of tariffs. The trafficking tariffs fail because they did not deal with the threats set forth in those orders. The challenged tariff orders will be vacated and their operation permanently enjoined. However, the U.S. Court of Appeals for the Federal Circuit provided the Trump administration with temporary relief from the lower court injunction forbidding the implementation of the tariffs. The appellate court stated in its per curiam May 29, 2025 order, drafted by court clerk Jarrett Perlow, quote, the request for an immediate administrative stay is granted to the extent that the judgments and the permanent injunctions entered by the Court of International Trade in these cases are temporarily stayed until further notice while this court considers the motion's papers. The plaintiffs' appellees are directed to respond to the United States' motions for a stay no later than June 5, 2025. The United States may file a single consolidated reply in support no later than June 9, 2025. Basically what this means is stay as posted. The appellate court is basically leaving the tariffs in place while it reviews the administration's appeals from the U.S. International Trade Court. A ruling on the administration's appeal should be forthcoming sometime after June 9, 2025. Keep following Executive Coup for further updates on these matters and others related to the apparent executive coup attempt that is unfolding in the U.S. federal government at the direction of President Donald J. Trump. Thank you.